Thank you for being here. I'm going to call the special meeting for October 14th, 2013 of the Ojai City Council to order, and I'm going to ask Councilman Lara if he could lead us in the Pledge of Allegiance, please.
Ready? Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Councilmember Lara.
Here.
Councilmember Clapp. Here. Mayor Pro Tem Strobel.
Present.
Mayor Blatz.
Here.
And Councilmember Smith is not here at the moment.
All right, well, this is a special meeting of the Ojai City Council, so we only have one discussion item on our agenda this evening, and it is a resolution confirming the effective date of the Report of Residential Building Records requirement. Mr. Clark?
Thank you, Mayor and members of the City Council. In our housing element, in our fourth cycle housing element, we have what is called in there the amnesty program, but which we also call the second dwelling compliance program. And as part of that program in the housing element, we indicate that we will institute a report of residential building records upon the conclusion of the amnesty period or the compliance period. Subsequently to adopting the housing element, we adopted several ordinances which implement the housing element. And one of those ordinances implemented this report of residential building records. And it came to our attention last week that in that ordinance, we did not indicate when that goes into effect. And of course, the intent of the general plan was that it go into effect upon the conclusion of the compliance program. So there's several questions that will need to be addressed over time. One is whether the council desires to have a report of residential building records or not. And we think that the time to have that discussion is when you consider the fifth cycle housing element, which we expect will come to you in December. In the meantime, it's necessary, we believe, that you take some actions to correct for the record that the current housing element provision and municipal code provision is not being enforced. In order to actually change the municipal code, it requires that you adopt an ordinance, which requires a first reading, a second reading, and then 30 days until adoption. And so tonight, as sort of a stopgap measure, we're proposing a resolution which indicates the intent to make this effective upon the conclusion of the compliance program. We're also recommending that you direct us to notice a public hearing for the next city council meeting so that you consider an ordinance that would actually amend the municipal code. So that's kind of a summary. I'd be glad to answer any questions that the council has.
I just have one question. The way that it was set up, even though the statute went into existence, I believe in July of 2013, didn't that statute reference that it had something to do with what would happen after the amnesty period, which would be July of 2014? So that it really, even though the statute was put into place, it was ambiguous as to how it was supposed to be managed or enforced, because it really said that it wasn't going to be in effect, even though the statute was in effect, until a future date.
Well, in my mind, when we discussed this at the last city council meeting, I felt that the fact that the housing ordinance states that it won't go in effect till then, and our guidelines state that it won't go in effect till then, was sufficient. But the fact is that the ordinance doesn't state that, and therefore we felt that just for clarity, peace of mind, and to make sure that it's clearly understood, we should adopt the resolution now, which again is just a stopgap measure until we can do an ordinance, and then actually we will propose an ordinance which changes the municipal code to reflect the appropriate date.
Okay, any other questions of the council? No? All right, I have one speaker. This is a discussion item. We have many people here from the public that I'm hoping to hear from, but I only have one speaker's card, and that's from Craig Beam. Oh, if you could bring that up. And if any of you do want to address us on this item, please fill out a speaker's card. It just helps us when we're taking the minutes so we've got everybody's name spelled correctly.
Thank you,
Bean.
Mr. Mayor, members of the council, staff. I'm here as a volunteer. I'm not speaking on behalf of anybody. I'm merely giving you my thoughts. The reason is I've been a real property attorney for 40 years. I've been a city attorney. I'm a member of the public law section, and I've dealt with a lot of the issues associated with this matter. And Rhonda kindly sends me all your agendas and what have you. So long before I think these good people became informed, I looked at this and said, this has got some serious problems with it. Sorry, Carol, let me speak up. I'm here as a volunteer. I'm not here on behalf of anybody except just I like to see good government in action. I think this is a real problem. Let me make an observation. When I looked at the city code to see what was proposed by way of a report, my reaction was, wow, if I were a city attorney and I was working under a contract where I got paid on an hourly basis, I'd love this idea because I don't have an idea what it means. I have no idea what areas of law or conformance with regulatory matters is supposed to be addressed. Clearly things that come under the Health and Safety Code, under the MAP Act, under the UBC, what have you, are all involved. But I don't even know whether or not we're supposed to look at matters associated with today's regulations or yesterday's regulations. Do we care? Of course. I mean, half or more of the dwelling units in Ojai are probably 50, if not 60 years old. So what are we looking at in terms of compliance? This does not provide a hint. What are we supposed to do? Is this retroactively saying you have to come up to code in all matters? Is that possible? So from my standpoint, that's really difficult. I couldn't tell whether this is intended to apply to all residential dwellings in Ojai, which seems to be the case, where originally this started because we had people that had converted without regulatory permission or what have you, some aspects of their dwelling for effectively a second unit. The only effective second unit provision that I know of that applies in state law is what's called the granny flat provisions. That is a modification of the State Subdivision Map Act. Just one of the statutes that regulate these kind of activities. So when I looked at this, I also put on my real estate lawyer hat. I'm very familiar with the CAR forms. The California Association of Realtor forms are probably the best in the United States. They give all kinds of opportunities for disclosures, for warranties, for anything you want under the CAR forms. None of that seems to be taken into consideration. And last but not least, I looked at your resolution before you that staff drafted and gave to you. It says, let's make a decision. What we're going to do is setting an effective date today, and then we'll have a public hearing and take testimony on what we're going to do when we have a public hearing. I'm sorry, that's kind of a due process issue. You can't make a decision what you're going to do tonight and have a hearing on it, in the future. So I would offer my comments. I don't think you want to go down this path. I don't think you have the staff to do it. I don't think you want to pay the attorney time to undertake this. This issue, at least as presented, has serious considerations that I would hope you'd look at in detail. Be glad to answer any questions you have. Thank you.
Thank you, Mr. Beam. Don Shook? Did he take your paper?
Well, my paper was here first. Hi, I'm Dawn Shook, the Executive Officer of the Ojai Valley Board of Realtors for the past 16 years. Years ago, at Dale Hansen's suggestion...
Could you lower the mic a little bit so that
Oh,
we
I'm sorry.
can pick you up?
Okay. At
There you
Dale
go.
Hansen's suggestion...
There you go.
She's our local government board of director. We began inviting dialogue with the city of Ojai at our monthly board of directors meetings. We've had Katrina Schmidt, Tom Fig, Jerry Kirshner, Brian Meadows, Rob Clark, Stephen Foster, and Rob Mullane, just to name a few of the city of Ojai officials we have created a rapport with. On any real estate related issue we have spoken with and have invited each one to speak with us and developed a trust within the city. Our views are known and discussed at each of the monthly board of directors meetings. Any point of sale issue we have discussed discussed with the city and made known we are not interested in being part of any possible lawsuit this might be, considered. This is our living, and being the enforcers of the city real estate-related issues does not set well with us. We have been assured from Rob Clark any point-of-sale issues would be discussed with us to gather our opinion on the subject. We have always been clear on our position regarding point-of-sale issues. Right now, as I stand here at this emergency meeting, we realize there's been a breach of trust within our relationship with the city, and we cannot accept such behavior. The trust we have developed between the City of Ojai and the Ojai Valley Board of Realtors has been diminished substantially, and why? This issue needs to be resolved now for all of us. Thank you.
Thank you. Larry Wild.
Put that up a little bit. Hi, Larry Wild. Thank you for listening to this. I'm live in the city limits. Been a real estate broker for 38 years here. Happy to have a city council, happy to have a planning commission. Love the fact that growth is not taking off in an exponential way like it is in other cities. That's why I live here. But what I don't like is what is up against all of you. This is going to, in my opinion, put a tremendous hardship on a lot of innocent people out there. This isn't an issue of real estate brokers or agents making a disclosure issue. We do that. We're going to be fine. It's going to be all of the innocent people who are going to have to go through the bureaucratic red tape, tie this stuff up, have delayed escrows, cost them additional money. And I think if it's a question, and I don't know that it is a question of this, if it's a question of revenue that the city is lacking, go tie it to the vacation rentals. These people want to, many of them, not all, want to pay you guys. You're not taking it. Take the revenue, but don't take it out on the little guy. You're really going to have a huge impact, in my opinion, on this place, as I said last time up here, turning this place into a little Santa Monica, Moscow. And if that's what you want, God bless you, but it's not what I want. Thanks for listening.
Thank you, Larry. Anyone that hasn't filled out a speaker's card that wishes to speak? Dale?
Good evening, Dale Hansen. I live in the city of Ojai. And thank you. I know this is an inconvenience for all of you, and I really appreciate your allowing us this emergency meeting. What I'm here tonight for is just to make a few simple comments. I'd like to see you rescind the language regarding the building records program. Is that good? Okay. Did you hear what I said? Okay. I can repeat it. Okay, we want you to rescind. We would like you to consider to rescind the language of the building records program. It doesn't work for us. It doesn't work for homeowners in the city, and I totally agree with what Larry Weil just said. I'd also like to ask that you be more transparent. We didn't know this was being passed. We had no advance knowledge of it. We have good relationships with the staff, and this kind of snuck up on us, and it may have snuck up on you as well. So in the future, I would like to hope that you would contact Don Shook or Steve Strike or any member of the Board of Realtors and give us a heads up so we can come here and be part of the vetting process. That's what we would like. In addition to that, Larry also made a comment about this. And I'm going to leave this with Rhonda, and any of you can look at it. My broker, Ron McCrae, pulled this off the internet. This is the California Association of Realtors contract that we all use. It's both the residential purchase contract and the listing contract. And in it, you'll see several places where it's been highlighted that we disclose to the buyer and strongly advise them to check everything out. A buyer's investigation of property and matters affecting property. There's several places in here. Then in addition to that, there is an attachment that goes with it, and it's a buyer's inspection advisory, where once again, it is spelled out that they need to check with any kind of permits or zoning clearance. I understand that you may have to redo the fourth cycle of the housing element. I know that may be a nuisance, but I really think that's what we have to consider. Thank you so much.
Thank you, Dale. Yes. If you could state your name, please.
Steve Strike, Board of Realtors, President of the Board of Realtors. Thank you for having this meeting. The first thing about rescinding something that you proposed to the state, our fourth cycle, if we would have seen this beforehand, before this was submitted, we wouldn't have to rescind anything. So to me, that really doesn't seem like much of a stumbling block. The CAR forms, California Association of Realtor forms, that Dale has that you can all look at, and it looks like Paul knows something about them. This is a team of the top lawyers in their profession have written these forms and stand behind these forms in every transaction. The country, these forms are used across the entire United States because of how our legal team has written these forms for years now. We're the experts basically on these forms for homeowner transactions. And believe me, we ourselves know one of the most important things is for our buyers to be completely educated regarding the properties they're purchasing, not just for our own covering our own butts, but we really, that's our job. We're in there to represent our buyers and to make sure that they know what they're getting themselves involved in. So is it possible to rescind this now? Can I get an answer to that at this meeting? It's impossible to rescind this.
At this point in time. It's not impossible to rescind it in a future date, but not at this point in time.
So at this time, all we can do is postpone it.
Well, clarify the effective date of it, and then in the meantime, prior to that, having another public hearing on it to discuss all the issues as to why we shouldn't have it.
And then Wayne Wyrick mentioned something regarding the Brown Act, where if something hasn't really been brought to exposure of the city people, that it really doesn't even count, for that reason. So I think that should be something else that we really need to consider here with, I think, maybe all the verbiage of this fourth element that we haven't been exposed to. So I really, I thank you for the meeting, and I hope that you guys will do whatever we can to stop it today and to rescind it tomorrow. Thank you very much.
Thank you. Anyone else? Hold on, Bill. Hey,
Hello,
Tom.
Tom Weber, resident of Ojai. Dale had just shown you the copy of the purchase contract that we use, and I've gone through and pulled out the other disclosures. There are 23 disclosures, most of it in bold print, that informs a buyer to go do any number of inspections, including coming right down here and pulling records, or at the county or wherever. And I came in earlier and I talked to Sherry and Ann and about that very thing, on just in general, how many people come in here. And I know it's not an exact number, but just anecdotally for what she feels. And she says on any given day there's at least one person, maybe 5 a week, maybe more, that come in and look at the records here. And so I just kind of took that year to date. That means about 190 people. Now, maybe some are looking at the same file and over again, or who knows, but we've had about 115 closed transactions, single-family residences in Ojai, also year to date. So it seems to me that the public must be getting the message and coming in and reviewing records already. So my complaint, and I think most of realtors' complaint, is we don't want any more disclosures for them. We've got plenty of, I hope my grandkids have a shade tree at some time. So what I think, that's the first thing. Also, the language where we need to compel, or a buyer can compel a seller to provide some paper and or their representative, which in most cases I would suppose would be us. We have no power to do that. And in addition, just like Steve had mentioned, our forms are prepared by California Association of Realtors legal team, which is huge. And they back us up on all of these forms. So that's why I use only their forms. I don't make up my own stuff. I use just their stuff because I know they'll defend me should there be a mistake or some question, a legal question on the form. I'm not happy with I have a draft of the one-page document, which I understand this is going to be changed yet again, but your one page for the records that I'm supposed to fill out. And I notice that this form specifically releases the city from any liability of the inaccuracy of the records that you might have over here. Doesn't release us, and so we don't want to be part of that. If you need a properties, if you think the buying community needs to review, that they're not reviewing records, which I think they are, and they are certainly told many times to go do that, and if they don't want to, hey, sorry that you don't want to. But if you want to do something at all, then make it the buyer's responsibility. If you want to do a public service announcement in the paper, hey, every buyer in town, come on in, we'd be happy to give you a file. And by the way, we're not liable for the file, and it's only good for the moment that we just handed it to you. So I think that part needs to be removed completely. It is just, there is no need for it unless you can tell us what was the need in the first place. What is the problem you're trying to solve? Thank you.
Thank you, Tom. Bill?
Bill Miley, North Signal Street. Tonight I'm speaking for myself, but I'm going to refer to the Ojai Democratic Club Housing Committee, which I was a member of and still am a member of. And when we spoke to you at the time you were considering adopting the draft housing element, we asked you very strongly to consider extending the time period for the second dwelling compliance program beyond June or July of next year, because to give a lot more folks time to become involved, to understand the amnesty program, to talk to an ombudsman, and to my knowledge, the ombudsman positions haven't been filled, or if they have been filled, they haven't been put into action from my point of view. So nobody can do anything, and we still have a deadline. And your council, as far as I know, didn't seriously consider extending that deadline. And I'm sorry about that. I wish you had. So I have two questions I want to ask you and hope you can answer today. Because I think it's like a jigsaw puzzle. This whole thing is like a jigsaw puzzle, and there are a whole bunch of missing parts. Okay? Question number one. Why is the building code review that we're talking about tagged on, in my words, to the second dwelling compliance ordinance at the time it dies? When the compliance program is over with, then we're going to have a building review program that's required. Why is it tagged on to that? And is this building file review program, ordinance, whatever, is it intended to apply only to second dwellings who are amnesty dwellings, or regular second dwellings, or does it only apply after the second dwelling program dies? Or does it apply to all residential, all commercial property in the city? And the only way we could get it in the ordinance was to tag it on to the second dwelling program. It just doesn't make sense. So I would like to know, there's two questions. Why did you tag it on to the end when it dies? And is it to cover all residential property, all commercial property? You know, you could modify a commercial building without a permit, I'm assuming. So, please, I'd like to hear that. Thank you.
Thank you, Bill. Mr. Clark, can you respond to Mr. Miley?
Sure. I wasn't here when this was first devised, but typically what happens is that you have an amnesty period, and then at the end of the amnesty period, you have a reward or a penalty. a reward for those who got amnesty and a penalty for those who don't. So I think at some point in time when the housing element was being discussed, this idea of the residential records report and also the idea of an inspection upon sale came up and was discussed. And those were incentives for people to participate in the amnesty, a benefit to those who did and a penalty for those who didn't. And so, yeah, it did apply to all sales of residential property. Since that time, the inspection program was pulled out. And when we more recently reviewed the housing element, the report requirement was still in there.
Okay. Steve, did you want to say something more?
So, Rob, just correct me if I'm wrong. So this is in place as some type of a way to punish people who haven't participated in the amnesty program? This verbiage?
I resent your punishment. This is an amnesty program. At the end, you either have a reward, which for us, we have offered health and safety is only thing we're concerned with. People who have non-permitted second dwelling units with no permits, if they meet the plumbing, the safety, the fire hazard, they don't have electric orange cords running from their garage, we will do everything in our power to make that legal.
I think that's
without the
fantastic.
setbacks, and it's a fantastic program.
I think it's
I
great.
cannot think anyway.
I'm not speaking
So I
on
do
that.
not, well, this is what I'm speaking on, and I see here a twist in here. We are going overboard to make this work for our community. And that's the only thing it applies to, is to non-permitted dwellings which are being rented as separate units, which are not up to health and safety. We're giving people a chance to make them safe, to have them on the record as legal units. They will go to the county, their property will become more valuable, and they will pay more taxes on it. I think it's a fantastic deal, and I am shocked that there are people in this room who have followed this for years, and they are now saying they don't want it.
I don't believe that's what we're speaking to. We're speaking to the verbiage regarding the inspection notice from buyers to sellers. And what Rob just said, and I just want clarification, maybe he didn't mean this, that this verbiage was put in place to detect people who should be rewarded or not rewarded based on following through with this amnesty.
That's correct.
Yeah. That's the reason for this verbiage, Rob?
So again, Mayor and Council, I was not here when the verbiage was put in place, so I'm surmising from what I've heard about the past, but I believe that the idea was to provide an amnesty period, and then at the end of the amnesty period, to have measures which were beneficial to those who had gone through the amnesty and not beneficial to those who did not. So in this case, if you went through the amnesty period and then later you sold your house and the record was produced, it would show that your second unit was permitted. But if the amnesty period passed and you had an undocumented second unit, it wouldn't show up, and so that would probably spur the buyer to look further.
Mm-hmm.
Not only that, but in order for them to make it legal, in order to make it legal, they would have to follow all the setbacks, everything that we would have required had they gone for a permit to begin with. So we are offering a big carrot here.
Steve, have a seat for a minute. Let me make a couple of comments. The only council person that was on the council at the time that the initial amnesty program was brought forward, and at the time that this language was put into that amnesty program, was Councilwoman Smith. No, I was there too. Oh, and excuse me, and Councilwoman Clapp. When it came back before us this time, and I'm as guilty as perhaps other members on the council, I wanted to make sure that there were no provisions in any of the code that called for inspections upon sale, and that's specifically what I was looking at. I was very familiar with the Buyer's Inspection Advisory, which is a California real estate forum, which to me, by state law, says exactly the same thing that this ordinance says, except for the fact it gives the affirmative duty to the buyer or for the seller to say, if you want me to provide you with a report about my property, I have an affirmative duty to do that. Other than that, it's the same thing, and that report would come from the city that would do nothing more than to look into the file and report what permits are there, not go out and inspect the property, but just to say what permits are there. Quite frankly, I think that people can take care of things themselves, and that the disclosure statements and the advisories contained within the standard real estate forms are sufficient enough. But I was looking at it more this time purely on an inspection on sale, which would then give Big Brother the opportunity to go in and start citing all kinds of properties for the people that didn't come forward on the amnesty. That wasn't the intent here. This was available for all of us to see, the council and the public. I looked at it, and including the advice of Mr. Fletcher, don't believe there was a violation of the Brown Act in the way it was noticed. But I wasn't paying attention to the fact that I thought it was going to be that big a deal. As a councilman, I just didn't think it was going to be that big a deal, considering how onerous the advisories are already. Now I'm beginning to think, yeah, it probably is a big deal, because not only is it a big deal that you have to go and have the city prepare a report for $500, but I didn't give a thought to, having to wait to get the report done and how long that was going to take, and if that was going to cause there to be a delay in closing escrow, because once you get the report, then you have to go on. But that's really not what we're here for tonight. We're only here for tonight is to, because there was ambiguity into whether or not all of you had to start doing this now, we wanted to make sure either you did or you didn't. And if you don't need to, then we're going to have plenty of time to discuss the actual provisions of that ordinance in the future. So I can appreciate everybody being here, and I thank you for being here. And I'm sure other members of the council have comments to make, but that's kind of where I am. I would like to see this definitely put off for any kind of enforcement and inaction until July of next year, and in the meantime, we can take a closer look at it. I really thought that this was also going to come up as part of the enabling statutes for the amnesty program, and weren't part of the initial statute that we actually voted on. So I apologize to the public for that.
Mayor,
yes.
I couldn't agree with you more. Tonight, we're asked to adopt the resolution confirming the effective date of the report of residential building requirements, which should go along with the end of the amnesty period, which is July. There's no doubt about that. And set a public hearing. The question, though, once we do that, and I don't know, I haven't talked to my colleagues, but I think that's very clear that was a mistake. It should not go into effect until July. The fact is, though, to null and void the amnesty program by not having any reward for owners who currently have a non-permitted unit and come forward and do the right thing, what's the point of an amnesty program? What is the point? And that we could discuss, but I'll tell you clearly that amnesty program is 300 of the units that we applied for in our housing element. Without that, we do not have a valid housing element.
Mr. Mayor, Mr.
Mayor,
Mayor,
hold on,
Mr.
hold on.
Mayor,
Wait.
Mr. Mayor.
Councilwoman Clapp?
Thank you. I think we're mixing up apples and oranges here. I'd like to get back to what we're talking about. I don't think anybody's asking for the amnesty program to be nullified. I don't think anybody's asking at all. Okay, I think there's some confusion. Oh, please, okay. Okay. Breathe, Betsy. Okay, I have a few questions that I'd like to ask. First of all, a statement. We had Cycle 4 and Cycle 5 bumping up against one another. And there was this incredibly intense moment in which if we didn't get Cycle 4 submitted, we were going to be in deep trouble. So I think in the haste, this slipped through. I don't think there was any intent to try to generate revenue or any attempt to be deceitful or anything. I think this was just one of those things. I think you all understand how when things get sped up sometimes, something slips through the cracks, and maybe surely it shouldn't have, but it did, so I apologize. My first question, Mr. Clark, is when does Cycle 5 get adopted?
Right now, we're scheduled to adopt it in December at the earliest.
Okay, December at the earliest, and at
And
the
the reason, I
latest?
say that for a couple reasons. One is that we're waiting to get comments from HCD. If they make their comments within 60 days, as they're required to make, then we should make the Planning Commission and the City Council. Secondly, it's only if you're ready to adopt it in December. You may want to make some changes and bring it back or something like that. So there is some room in there for that.
Okay. My question with that, so we're talking in a couple months, we would not even be in Cycle 4 anymore. So Cycle 4 and the requirement of Cycle 4 for the residential building records report would die with Cycle 4, right?
Correct.
Okay.
Cycle 5 replaces
And does Cycle 5 have the records report request in it?
the draft. that
Please,
was
I'm talking to Mr.
The
Clark.
draft that was submitted to HCD does have this similar language in it.
Okay.
But it's really a policy call on the part of the City Council as
Right.
to whether you want to include it or not. You could take
Right.
it out if you want to.
Okay. So that could be addressed in December. So that would keep Cycle 4 in effect until we finally do adopt Cycle 5, correct?
Yes.
Okay. My next question is this report is not required by the state, is it? Not? It's not required, is it?
The language in the state law is may, so you may adopt the report requirement, or you may choose not
So
to.
it is not required by the state. Okay, so this is discretionary on our part. And what is the purpose of the records report? In 30 words or less?
Disclosure.
Disclosure. And is that disclosure taken care of in the California real estate form?
I'm not an expert in the California real estate form, but you can receive that same information by coming in and reviewing the file over the counter.
And I would like to ask Mr. President Guy, what's your name? I'm sorry, what's your name?
Steve Strike.
Strike, Steve. Yes, now, on that form, you're saying that the verbiage was given to our clerk, was it not?
That's the
Could you
form.
read what it says in the form is what you're recommending a home buyer do?
Let me just show you really.
Yeah, that'd be great. Is it okay if he comes up?
You can actually have this, 'cause
Okay.
we can print this out
Can you
sometimes.
all right,
And
where?
I will show you the most important form. This buyer inspection advisory form
Okay,
tells them every single thing that they should check out throughout here, but all these forms.
Okay.
have-
It's been a while since I bought a
have
house.
Notes that show for the buyer to,
Yeah,
look
and this
at
is a
house.
form.
This is the BIA, this goes with the.
Right.
And the important thing about the buyer's inspection
Disclosure.
specifically is that it obligates the buyer to look, not the seller to do the buyer's work. So the seller doesn't
Mm-hmm.
get indemnified if there's not factual evidence.
Okay.
please
Thank
be
you, Steve.
quiet.
Thank you.
Okay. Wow, so we have like 2 pages of disclosure. We have another disclosure statement here. We have a buyer inspection elections thing. I think everybody does a home inspection report anymore before they purchase a home anymore. So it seems to me, just as a, like an aside, that this is well covered by the California real estate form. So my question now is, the only way that we can take the onus off Cycle 4's requirement is to adopt this resolution, right?
You want to take it?
Maybe I'll try to answer. Well, 2 things. The policy articulated by the council when you approved the housing element was to defer implementation of the records report until the end of the amnesty period. My opinion is, irrespective of what the ordinance says, and I recognize it's ambiguous because it doesn't have a separate provision about its effective date, because the council set the policy that this program becomes obligatory at the end of the amnesty period, which in the document was July of next year, but there's already been discussion of extending the amnesty period, that you have the discretion to do. So I don't believe that I think my opinion is that it isn't an obligation that the city would be enforcing today.
And this wouldn't
But it
wouldn't extinct the amnesty program either if we were to
absolutely not.
adopt it.
So the problem is not with the element. The housing element is clear that there's the amnesty program. At the end of the amnesty program, there should be a records report, a program to go into effect. What we need to do is clarify just officially, the purpose of the resolution tonight is to affirm what your policy already has been, in that this doesn't go into effect until the end of the amnesty period.
And which is when?
Right now, July 1.
July 1 of
next year, But there's
2014.
already conversation, and
Okay.
we've heard about requests to extend the amnesty period, which you have the absolute discretion to do.
Okay.
But to take it out of, you can't, it really is
So
impractical, not impossible, to take it out of the fourth cycle housing element. It really, because it's in the element, and you wouldn't want to go back and actually amend a housing element that you're about to supersede with another cycle.
So we're better off to get cycle 5 done ASAP,
Absolutely.
do the resolution,
But
clarify
yeah,
that it doesn't go into effect until July.
correct,
That
and
takes the
adopt
onus
an
off the
ordinance.
realtors, does it not?
I'm sorry, ma'am?
It takes the real onus off the realtors, correct?
You-
They
you-
don't have to do this.
It would make it very
building.
clear that the city is not enforcing it, and I would
Okay.
recommend this, in the other element of the staff report tonight, is to recommend that we set a public hearing to amend the ordinance to conform its effective date to the housing element, which we are prepared to have you do
Would that
on the
even be
22nd.
necessary if we, well, I could see how, yeah.
In terms of protecting
Yeah.
the sellers, the buyers,
Right.
and their agents, and making it unambiguous
Right.
about when this goes into effect, it would be the very best thing I think the city could do to make the record clear.
Okay, so then in the meantime, we get the cycle 5 back, we address this issue in the cycle 5, whether or not we want to have this requirement in our cycle 5 housing element, right?
Correct.
Okay,
Anything else?
no?
Mayor Pro Tem Strobel, anything?
I think I've clarified that everyone's in favor of the amnesty program. We're going ahead with that. I do think it needs a carrot and it needs a stick. If this is not the stick that it needs, then I'm open to other sticks. But without a stick, you're not going to get compliance. I'm sorry. You know human nature. I don't want the onerous work on the realtors. I think the professional realtor does a fantastic job of letting the buyers and sellers know to be educated, to come down here and find out. I have never worked with a realtor, and I've changed houses a number of times, who did not make sure that his clients were well taken care of. The problem, and so I'm clear with that, and I think we should change it to July 1 tonight, whether we want to work for the next few months on what is going to be. I know your hand is up, sir. Wait for the mayor, please, okay? What we do in July to look at cycle 5 is possible, but I truly believe that the whole idea of an amnesty program is for people to come forward, to help them do the right thing, to make their units health and safety. So I'm much in favor of the recommendations for tonight.
Mr. Mayor?
Mayor Blatz?
Yes,
I do have
Councilman.
a couple comments. The first is a question for the staff. I'm just trying to wrap myself around this issue. I've never bought a house, and so I haven't had the pleasure of going through the whole disclosure statements and application, so forth. But I, as a first-time buyer, I want to make it as easy as possible. I want to go through the process. So with that said, I'm trying to understand why this procedure would go into effect at the end of at July 1st, 2014, rather than, and why they're not doing it now. To me, it seems like they would.
So I think I can answer that question. I think that the idea, and again, I wasn't there at the time, but the idea was to give people time through this amnesty process to get their units permitted. Then when that time had run and their units were permitted, if they sold their house, they would get a piece of paper from the city that says this is a permitted unit.
Okay, so
So it was an incentive to do that.
as an incentive,
Yeah.
you would encourage homeowners to do a second unit compliance, come forward and meet all codes and pull all the permits that are the correct ones, or to make that legal. Okay, second question is what Mr. Beam brought up, the due process. Are we really doing the right process of bringing up this resolution, or is there a better option that we should be following in order to?
I don't agree with Mr. Beam there's any due process issue here, because the action this evening is merely confirming what's already in the housing element. We're not changing, we're not amending the code tonight. The housing element stated the policy of the city council that the property records program begins upon the expiration of the amnesty period. That's why we're only doing it tonight as a resolution, to try to make as much disclosure and make the record as abundantly clear as possible. That's why also saying that we would require a notice of public hearing at your next meeting, because the state law does require a notice of public hearing to amend any provisions of the zoning code. Now, I do believe, by the way, that we are not changing with if you were to go forward, as we would recommend, to amend that section to give it what I call a sunrise provision of the end of the amnesty period. I don't believe that is actually an amendment to the zoning standards of the city. It's a merely technical issue of a date. So we're not proposing to going through the planning commission, because we're not adopting any new zoning standards. We're merely amending an existing zoning standard the city council already adopted after a public hearing with the planning commission and the city council. But there will be a Brown Act notice, and there'll be published legal notice, and it'll be at a public hearing. So plenty of due process there. I think that's the correct way to deal with it.
Anything further?
No.
I have a real quick thing to say. This is just an aside, Councilwoman Smith. I think the biggest impediment to the amnesty program is the sewer hookup fee of $15,000. I think that's the biggest impediment. And I know that we had a time frame in which they gave a break on that, and then it went up to the 15,000 again. And I think if there's anything we could do to encourage the sewer district to maybe bring that whole concept up again in cycle 5 in order to encourage people to come forward, so it isn't $15,000 to hook up to the sewer. That might be a way that we make it more successful.
My understanding is through the camera work, they know exactly who the people are who have illegal sewer hookups. And very justifiably, they need to bring those into compliance. What the Ojai Valley Sanitation charges for it is the question.
Right, because whether it's a 5,000 or 10,000 or 4,000 or 2,000 square foot or a
And
750 square foot second dwelling unit, it's all $15,000.
I don't know how many people did come forward to take advantage of the amnesty.
All right. Mr. Daddy, did you have a comment?
Yeah, I had a comment.
Come forward, please.
I wanted to know if you closed the public discussion because you went to council. Okay. I wished we could rethink this July 1 for this reason. We're 115 days into this amnesty. We haven't had a public notice of workshop. We don't have an ombudsman. We haven't done anything. This thing started July 1st. We're the middle of October and have done zero. We're no steps ahead. I really want to see this thing going. When this thing came up, I said, let's take all of these things and let's get all of them done. No more sewer users, no more water hookups, no more traffic, no more nothing. Let's get these certified that we have first. Let's work like crazy and get that done. Everybody's for that. What I'm not for is setting a deadline before the first day. When we find that we have used half of this program and have not started, then why is it still mandatory to have a July 1 drop dead date? Now, I know Bill Miley asked, I know Judy asked, I know the Democratic Club asked as part of their committee, and we said 66 years we've been required to have permits here since 1947. Why do we have to cram this thing down into less than 8.5 months now?
Bob, we don't have to.
Well, but that's what I'm hearing
There was a date put on it, and that date, I can, with relative certainty, tell you it's going to be changed. But we had all kinds of things we wanted to put into place, and it takes time, including the board that you so graciously are serving on, along with Wendy, who's here tonight, and Dale. And we wanted to give a year, and we thought that that's when it would go into effect. If it doesn't go into effect till the 1st of January, I see nothing wrong with us extending it to the end of December of 2014 or beyond.
Well,
I mean,
we
that's
would-
something that we have to look at, but that's not before us tonight, and it's not cast in concrete.
Okay, because I thought the vote was going to be on the resolution.
The only
To
reason the vote
not
is on the
enforce.
resolution is because it was decided that this particular provision would not go into effect until after the amnesty program. But the amnesty program right now is due to sunset in July of 2014. So we have to make them coincide. When we decide to extend the amnesty program, then obviously we're either going to do away with the provisions we're talking about tonight, or we're going to send it on to be on the same track. That's the
I
situation.
just
Okay.
want to make sure that everybody has adequate time. And we really get these people out there because they don't know what's going on. And I think 66 years of permits, trying to cram it into a year, is not enough time. Let's get those 300 units. Let's get all of these people available. Because if the people really get behind us, I don't see where we're going to have the time to cram that many people in. You're talking about doing more than one every working day. Now it's 2 every working day. That's not a possibility.
Right.
Thank you.
Mr. Mayor.
Yes, Councilwoman Clapp.
I think one of the things, too, is we need to have an ombudsman, and I was wondering if the clerk could tell us whether anybody's applied.
I've received one application for an ombudsman person, and two applications to sit on the interview panel. So I haven't gotten with the mayor to set up the date. I'm hoping to get more in for the ombudsmans.
That's part of it, too, is one reason we can't implement the program is because we have to go those things in place as well. Is that correct?
That's correct.
So we need also the public to help participate in this as well. So we need to get people to be on the interview panel and also, right?
Well, right
And
now I
people
have
on the
2 for the interview panel, which is sufficient, but I need more people to
Step forward with the ombudsman.
and volunteer for the ombudsman program.
And the ombudsman program can be, we can have more than one ombudsman, correct? Because people aren't always necessarily going to be available. So that's something that you guys could help us with, is contact people to apply for the ombudsman program, because that's holding things up as well.
How many do you need for that program?
The ombudsman?
I don't know, how many are we planning, 6 or 8?
We could have that many.
6 or 8? I think that's good. And I'm finally gonna get over to Mayor Pro Tem Strobel here, after I make one more comment, because I think we're gonna bring this to a conclusion shortly after you speak, is that we really need your help on some of these topics that this report was supposed to help. And I'm not saying whether I agree or disagree with it, but it doesn't seem like it's helping very much. That how do we try to reward those people that do come forward and do bring their second dwelling units into compliance, and those that don't? And when we finally get to the public area on that, that's what I'm going to be very interested in hearing from the public, because I certainly don't have the answers for it. Mayor Pro Tem Strobel, you've been very patient. Thank you.
First of all, thanks so many that have turned out this evening. I'm really happy to see you here. Whether you agree with me or not, it doesn't matter to me. I'm just glad you're here. I'm going to ask you to wait. I know we get these conversations going on in our heads when we're listening to something and we already have an idea of how we want it to turn out. I'm going to ask you to hold your comments, interruptions, until I finish. I love to start with little picky stuff. The ordinance, or the resolution that's before us tonight, the title, and in three different places, it says Title 16, Chapter 10. That's reversed. It's Title 10, Chapter 16. Chapter 16 is what we're really looking at tonight. So all through there, it's the title and the chapter is reversed. The resolution, Section 2, the second from the bottom of the page, it mentions that the records program shall not go into effect until the expiration of the second unit amnesty program without further action of the City Council in the event such program is extended beyond the current planned expiration of June 30th, 2014. Now, I don't know about everyone else, but that's very confusing to me. It's almost like going all the way around the house to come in the front door. It's unnecessary. We could have just as easily said, this program will begin upon the completion. But I really don't want to get into the resolution too much, except to pick on it. Because I don't know that adopting this resolution is a solution that would best meet our needs. In the staff report, page 1-2, there are 3 options that Mr. Clark has suggested are available to the council. And I'm just going to read option 3, which is where my thinking is also. If the City Council desires to rescind the requirements altogether, the housing element must be amended, preferably as part of the adoption of the 2014-21 update, and the municipal code section repealed. The process of amending the zoning code of which this is a part requires noticed public hearings before the Planning Commission and then the City Council and a determination that the proposed code amendment is consistent with the general plan housing element. That's where I am. That's one reason I've been rather quiet. And with that in mind, then I question the need to, if that's the way council decides to go, I question the need of having to adopt the resolution, which just sets the time.
Well, the thinking is that it would provide comfort between now and the time the new ordinance goes into effect that it eliminates it, and it would also provide comfort for escrows that have already closed since the adoption of this ordinance. So Mr. Fletcher has said he thinks that the general plan language actually would hold if it were challenged, but this just provides an extra layer of comfort for those who are concerned.
Okay, and that may be so, but we have books of resolutions, hundreds of resolutions. So I would question whether or not this, in the just reviewing of things, having this resolution on our books would actually create confusion, since we already know that the intent was for the ordinance not to go into effect, for this section of the ordinance, section 13, chapter 16, not to go into effect until June 30th, 2014. And we can, why do this ordinance, have it in our books? I see it as a possibility of confusing things when we can rescind the requirements and repeal that section of the ordinance. And that would not damage in any way the amnesty program. It simply would relieve or remove the reporting requirement.
Let me just give you my take on it. The statute that we approved is ambiguous enough, the Chapter 16, Title 10, Chapter 16, that it looks as though the ordinance that we put into effect has been in effect for 3 months already, and therefore would be in effect for 3, 4, or 5 months more until we decide that we're going to be, if that's our decision, to rescind the ordinance. This clarifies that to make it absolutely clear that there is no guesswork at what our intent was. This was our intent. And from my standpoint, I think it's better to be overcautious than less cautious.
Okay.
Any other comments? No? Then I'll entertain a motion.
Mr. Mayor. I move to adopt resolution number 13-46,
confirming the effective date of the report of residential building records requirement. Do we want to do it in two motions? Or all one motion?
Let's amend the title. It should be Title 10, Chapter 16.
Oh, with amending the resolution to state Title 10, Chapter 16. And do we want to have one and two in one motion, or do we want to do them separate?
Which would you prefer, Mr. Fletcher?
Why don't we do them separately, because you really
Okay.
haven't had much discussion on that.
All right, is there a second on this motion?
Second.
Okay, any further discussion? Roll call, please.
Laura?
Yes.
Clapp?
Yes.
Smith?
Yes.
Strobel?
Yes.
Blatz?
Yes.
Okay, now I move to set a public hearing on October 22nd, 2013, to consider an ordinance correcting the municipal code to reflect the effective date as provided by the housing element.
I'll second that.
Any further discussion? Roll call, please.
Laura?
Yes.
Sorry, Clapp?
Yes.
Clapp?
Yes.
Smith?
Yes.
Strobel?
No.
Blatz?
Yes. All right, both motions carry. Thank you, everyone on the council. Thank you, everyone, for being here. I hope that you, when we finally do start discussing the implementation of the amnesty program, that we can count on you coming up with some ideas for us. And I apologize, as one, for being the mayor, for not having realized the unintended consequences of the ordinance as it was proposed to have the buyer have to, or the seller to have to provide the report. So thank you for bringing it to our attention. Thank you. Meeting's adjourned.